This honorable court is now in session. Please be seated.
All right, Miss Angie, anything we need to deal with?
No, Your Honor.
You may call the next case, please.
In re Conservatorship of Susan Davis Malone.
And we're back.
We're back for part two, Your Honor. I think the court's well aware of who I represent, but I'll state it for the record again. I represent, again, the appellants in this permanent conservatorship matter, Your Honor. Myself and Ms. Blevins. I would like to, again, reserve 4 minutes for rebuttal, and I will be more mindful of my time this time, Your Honor.
All right, you may proceed.
Your Honor, as this court correctly pointed out, this has had a tortured procedural history, and I don't necessarily need to bore the court with what did or did not happen, because the record speaks for itself. And as the court correctly pointed out, all of the questions asked of opposing counsel were really regarding the 10B. So what I wanted to do is focus in really on what's in the best interest of Ms. Malone, because candidly, that's why we're here. And Judge Stafford, you ask, what's the root cause of the issues we're here? Well, candidly, it's the trial court. The trial court should have conducted a hearing. There's a number of issues we've raised in our brief, which we can't get to all of them, but we asked for a judgment on the pleadings, various things like that, which the trial court simply refused to address. So what I'm asking the court to do today is to vacate.
You anticipated my question. What's if assuming the facts are as you are positing them to be, that you filed motions for hearings which were not conducted, which were substantive, where does that leave us?
Where does it leave Your Honor? Well,
yes.
Honestly, I think this court can do any number of things because it has the inherent authority to take appropriate action, which it can see and believes in the best interest of Ms. Malone. So to cut to the chase, Your Honor, what we're asking the court to do is very much like the trial court originally posited in its order, where it voided the documents executed 2 days before the physician's affidavit, which were the November 16, 2022 powers of attorney in favor of Ms. Jackson. We're asking this court, to simply validate and confirm the September 19, 2018 powers of attorney in favor of myself and Ms. Blevins. And if the court does that, then should this court send it back down for further adjudication on the permanent conservatorship, the statute I quoted earlier directs the trial court that says shall appoint the individuals designated in writing absent a finding of a good cause or disqualification. So I think rather than send this down to effectively start the entire procedure over, which is a disservice to Ms. Malone, this court has inherent authority to remand this case, to send it back with a direction to the trial court that says, here's where your starting point is. Start with the 2018 documents, and then should Ms. Jackson feel like there is good cause or that Ms. Blevins or I should be disqualified, that is the starting point. That should expedite the trial court's finding of who should act and what is in the best interest of Ms. Malone. Because you asked.
Have any evidentiary hearings ever been held in this case?
No, Your Honor. There have not. And so we would ask that because of the previous appeal, the emergency conservatorship, this court has that inherent authority to take that action in the best interest of Ms. Malone to start at that basic premise. So we don't have to go through protracted and extended discovery and engage and take the depositions of physicians who's already opined what their opinions are regarding Ms. Malone's ability, cognitive ability to execute a document on November the 16th of 2022.
So are you saying we should order the trial court to go back to the emergency conservatorship?
No. What I'm saying is if this court can confirm in the emergency appeal the orders issued by the court. the court can say, we confirm what the trial court decided to do, which was the voiding of the November 16, 2022 powers of attorney in favor of Ms. Jackson, and confirm the 2018 documents under the theory of res judicata.
Did you raise the defense of res judicata in this action?
We did. It's it's the first issue in our brief, Your Honor.
Did you note where we can find that in the record?
I did not. I don't, Your Honor. I don't have it in front of me, but it is raised as the first issue in our brief. And candidly, I raised it in the emergency, although I now understand it's a defensive argument, but I raised it in anticipation that that would be our request in the permanent appeal. Now, the other issue that obviously concerns, and again, I won't bore the court with its tortured procedural history. So I'll fast forward, because what we're asking the court to do today in the permanent conservatorship is vacate the January 23, 2024 order. And there's a number of reasons why, but I think a brief procedural history is needed. So December the 6th, 2023, this honorable court issues the recusal opinion that denies the recusal. December 7th, an emergency motion to clarify the status of Ms. Malone is filed by Ms. Jackson. December 11th, the trial court enters an order that discharges the guardian ad litem and the attorney ad litem. For reasons unknown to me, I have my thoughts. They're expressed in the brief. I'd rather not. I can, but reasons unknown to me, I can speculate. December 11th, the trial court enters an order scheduling an evidentiary hearing on the issues raised by the pleadings for 2 days later, December the 13th at 9:30 a.m. We file a response on December the 12th, raising a number of issues: lack of proper notice, no emergency existed. The only allegation was a dispute. I unfortunately was unavailable on December the 13th as well as the 14th. We also filed a second motion to recuse. The court then conducts its hearing on December the 13th, 2023. It enters an order on December the 13th, 2023 that scheduled an evidentiary hearing on the motion to recuse the trial judge for 4:30 that afternoon. December the 14th, it conducts an evidentiary hearing at 11:30 a.m. and solicits testimony from Mr. Bomar and Ms. Jackson. And then on December the 15th, it enters an order appointing an interim conservator, stating without reason or without evidence that Ms. Malone faced a risk of substantial harm, and that was the good cause of how it moved forward. It appointed Ms. Janelle Eskridge as the interim conservator and ordered myself and Ms. Blavins to deliver funds to Ms. Eskridge, which we did by 4:30 that particular day. January 23rd, 2024, it enters this order.
Mr. Autry, I'm sorry to interrupt your timeline there, but let me back up and ask you a question.
Yes,
The
ma'am.
December 14 hearing that
Yes,
you
ma'am.
said occurred at 11:30 a.m. on December 14.
Yes, ma'am.
Who was present for that hearing?
According to the transcript, it was Lisa Jackson and Bill Bomar, as well as Mr. Wade. And I believe Mr. Myatt was there, but I could be mistaken on that last point.
All right, thank you.
Yes, Your Honor. And so when that order was entered, the reason espoused in that order in paragraph 13 of the January 23rd, 2024 order, and I'm quoting, the trial court says, holding another evidentiary hearing to determine who should be appointed conservator would cause unnecessary delay and or needless increase the cost of litigation.
Is that another?
Ma'am?
Is that another hearing?
No, it was coming from the same hearing. This all stems from the December 14 hearing.
But didn't you just say that the order said holding another hearing?
Yes, ma'am. That's what
So-
paragraph 13 says.
So what is the court considering to be the first evidentiary hearing, the December 14 hearing?
Yes, ma'am.
Okay.
That's the
All right.
first and only one that
All
I'm
right,
aware
sorry
of.
to interrupt.
No, ma'am, you're fine. And then inside that same order, what the trial court does is directly contrary to what we just argued in the emergency appeal. The court concludes that Ms. Malone revoked the 2018 powers of attorney, He removed Janelle Eskridge as the interim conservator and appointed Ms. Jackson and Ms. Eskridge as co-conservators of the person, and Ms. Jackson and Mr. Royal as co-conservators of the estate. And so that was the single and only reported evidentiary hearing that happened really on 2 days' notice, 1 day's notice from the original order. And it espoused to have an evidentiary hearing on all issues raised in the pleadings. That was what the trial court ordered. And in our response, which had an affidavit as well filed December the 12th, again, for the procedural reasons, because it was simply a motion, we weren't available. And this, as the court has correctly pointed out, this has a tortured procedural history, and to attempt to schedule a hearing date on such a detailed matter with 1 day's notice, we don't think was appropriate in any way. But again, going back to what I'm asking this court to do, first I'm asking the court to vacate the January 23rd, 2024 order for a number of reasons, primarily which is certainly not sufficient notice for a hearing, an evidentiary hearing in this matter, particularly when the trial court was aware that we weren't available. But I'm also asking the court, when it decides, when it vacates, it can simply remand and start in the basic premise that I said the court should start with voiding the 2022 documents, validating the 2018 documents, and instructing the trial court to start with that proposition under the statute and ask Ms. Jackson, should she feel deemed appropriate, to find good cause or disqualification of myself or Ms. Blevins. I see that I'm out of time. I'm happy to answer any questions.
Thank you.
Thank you, Your Honor.
Good morning, Your Honor.
Good morning.
I'm David Wade, and I'm appearing for the co-conservators and the petitioners. In the audience with me is Lisa Malone Jackson, daughter of the respondent, and her son, John Parker Jackson, who is also a co-petitioner. One thing that's gotten lost in all this, although I think Mr. Autry hinted at it, is this case is about the best interests of Susan Davis Malone. Mr. Autry initiated this case on November the 22nd, 2022, when he asked the courts of the state of Tennessee to take her in as your ward. She was brought in because it was alleged that she was a person with a disability. Nobody has disagreed with that. She suffers from dementia, she suffers from paranoia. But one of the things that Mr. Autry didn't mention, he supposedly attached the affidavit of Dr. Warren, who was the physician at the rest home or at the nursing home where she was staying. It was not attached to the original petition, but it did come into the record in both cases later. And what Dr. Warren said is that she suffers hallucination and paranoia that necessitates a conservator. Nobody is denying that. But he goes on to say she is capable of adding her wishes in certain situations, and that she can have cogent moments that will affect her decision-making. That was not part of the record before Judge Townsend in the morning of November the 22nd. And the history leading up to that is very important.
You get me confused. Are you reaching back to the other case we just heard?
No, I'm trying to look at the history that leads us to everything, because this court has held and the trial court has held, they're inextricably intertwined. And what Mr. Autry has argued is the rulings that the trial court made in the initial emergency conservatorship. And those are the rulings that he wants to have binding on Susan Davis Malone forever, apparently. And those rulings had to deal with powers of attorney.
Mr. Wade, let me ask you a question before
Yes.
you get into that, and I'm sorry to interrupt because I know you're going into the background here. But, I would agree with what you said, that this is a very serious matter. We're talking about the best interest of a ward. And,
Yes.
once a conservatorship is established, just as you've said, you get into a situation where the court is responsible for this woman and for what is in her best interest, and that's a heavy responsibility. When I was in Chancery, I used to have a lot of conservatorships, and that's something that it's a very serious obligation that the court has. My question for you is, you have a judge here who's responsible for this ward, essentially. He's responsible for making decisions for this ward. What evidence, what's in the record to show the basis of Judge Townsend's orders that he's made? Because he's relieved people, he's pulled people, he's put new people in, he's made a lot of shuffling and changes throughout the time. What's the basis in the record, the evidentiary basis, and what did he use to find her best interest?
All right, he started out on November the 22nd. The orders that Mr. Autry's talking about were drafted by him. They were entered ex parte, accusing me and Bill Bomar of being in a conspiracy with other people. Mr. Autry knew about us and didn't give us any warning or any notice of that hearing. We were not there. The judge entered an order drafted by Mr. Autry and appointed Paul Royal as an attorney ad litem and Laura Mason as the GAL. That's the start of where we are. The court could not conclude the emergency conservatorship because of statutory reasons. The question of Ms. Malone's best interests came about this way. And I think what happened is everything up until about March was all going in Mr. Autry's favor, and he wasn't complaining about any of that. What happened on March the 10th was a hearing at which Paul Royal, who had been appointed the attorney ad litem, said, and Mr. Autry confirmed in the transcript of that hearing, that Paul Royal did not believe that he should be the conservator. That was the statement of the former attorney ad litem.
And I understand that statements are made, but what's the evidence here to the trial court that allows the trial court to conclude that Mr. Autry either should or he shouldn't?
What the trial court said in its order, and I do recommend, you're going to read it, but it needs to be
Trust me,
reviewed.
we've read it.
I know you're going to read it. That's the order at issue here. The trial court says, based on the testimony of Ms. Jackson and Mr. Bomar about what happened, based on that testimony and the entire record in the cause, there were affidavits that were submitted. The petition, co-petitioners, and the amended co-petition set out facts and circumstances that involved the care of Susan Davis Malone. She has made remarkable recovery under these co-conservators from where she was. At that hearing on March the 10th, the judge said she's about dead. So we're really talking about her estate. She was, the GAL in her report cited she was bedridden. She couldn't get out of bed. What happened over the period of time after the GAL in her report, the guardian ad litem in her report, recommended that there be a conservator appointed, but a neutral conservator, not Mr. Autry. What happened with respect to the second GAL report, she entered a report 2 weeks later that said there should be a neutral appointed, not Mr. Autry.
At this point, we're in the permanent conservatorship, is that right?
Well, that's what this case is about. Yes.
That's right,
Yes.
but I know we're bouncing back and forth.
Well,
For
it's not
historical purposes,
Yeah,
I understand.
It's not really bouncing back and forth because they're inextricably intertwined, which they are.
I understand
They are.
what you're saying, but I'm trying to get my points of reference.
So what happened next, there was a hearing on April the 11th. At that hearing, the court said, Mr. Autry, you're wearing too many hats. He was the petitioner. He wanted himself to be appointed conservator. He was the attorney for the petitioner, wanting himself to be appointed conservator. He was the one that was billing for his time. He was the one that was paying for the bills. Everything was all Mr. Autry. What needed to be done, according to Judge Townsend, trying to deal with this situation, was to unwind those conflicts, which is what he tried to do on April the 11th. If you read the transcript, you'll see he tried to set up a proposal by which Mr. Autry would be unwound from some of those conflicts. That's what he tried to do. He asked Mr. Autry to prepare the order. He said he would. He didn't. So on April the 28th, the judge entered an order setting those things out that he thought should be done. He set a status conference for May the 17th. We all arrived at May the 17th. Actually, on May the 4th, the court asked Mr. Autry what he had done, or asked what Mr. Autry had done, and he had done nothing to set up those things to try to unwind the conflict. On May the 17th, we all came together. Everybody was there. The court was trying to set dates for everything. Mr. Autry argued to you that the court refused to set dates for any of the hearings, motion to disqualify, motion to stay, or motion on the pleadings. That's not so. The court set July the 31st through August the 3rd to hear all of those hearings. And the court specifically said they're fact intensive. I've got to hear the facts. That's what I need to do. 2 days later, Mr. Autry filed his first motion to recuse. And that's part of the problem we've got throughout all of this. There was no discovery conducted because the case was stayed. It stayed that way. Mr. Autry's delays, technical arguments, continued motions to recuse, stopped everything. He's never taken any discovery in this case. He's never done anything to prove that there's been a conspiracy between anybody. All of that has been explained in open court. The judge knew all of that.
Let me go back to something. As I understand it, according to the brief, the issues in the appellant's brief, there's a pending motion to recuse or disqualify you and your firm.
Yes.
Has that ever been ruled upon?
That has not been ruled upon. It was set for a hearing. It was set for hearing starting July the 31st. The judge said all of these motions are fact intensive. If you take a look at that motion to disqualify, you will see it is hugely fact intensive. And we responded. But the judge did set it for a hearing. The hearing didn't take place because Mr. Autry filed a motion to recuse the judge because he didn't like the way the court was ruling. After the March 11th hearing, when everybody stood up and said that Mr. Autry should not be a conservator, there should be a neutral conservator, everything changed from Mr. Autry's perspective. No longer was he getting the positive rulings that he thought he should get, it was negative. And that's where all of the conflagrations, the difficulties, the technical problems started to arise. And they've continued ever since. It's not our fault we didn't have discovery. It's not our fault. We pushed to try to get this thing done. Judge Townsend repeatedly said he was looking after Susan Davis Malone's best interests. And there is no doubt that if you look at the declarations and the pleadings in this case, that her best interests have been served hugely. She's now, instead of being bedridden and her hair stuck to her head, she's getting out. She's going to church. Her daughter visits with her. Her grandchildren come and visit with her. Her friends visit with her. The carekeepers say they're so relieved that she's getting the attention that she needs. So our position is pretty straightforward. In all of this, we hear all of these different arguments about why this doesn't happen, this shouldn't happen. It's like Susan Davis Malone has gotten lost in all of this stuff. Her best interests are what controls what happens in this court. Nobody but Mr. Autry has said he should be conservator. Everybody else has disagreed. Frankly, Your Honor, one thing that Mr. Autry, he does things like this. He quotes from the first report of the Guardian ad litem. He quotes this statement from the Guardian. I have found no objective reason that Ed and Hannah should be disqualified other than the respondents' adamantly expressed wishes to that effect. She is definitely suffering from diminished capacity, but she has some wherewithal. That's what he quotes, that there's no objective reason that they should be disqualified. He doesn't quote the next sentence. It says, respondent is upset and confused, and the only solution at this point is to appoint a neutral third party to oversee the respondent's affairs. He does the same thing with respect to another quote. He leaves out the last paragraph of volume 4, page 476. All I can say is, looking at this case, Judge Townsend, in that January 23rd order, gave specific reasons about what happened. Mr. Autry said he was unavailable to come to the hearing. Judge Townsend lays out everything that was done for them to come to that hearing, and they refused 3 times. They didn't send anybody explaining why they weren't coming. They didn't come. So Judge Townsend said, I've got an emergency motion. What's going to happen to this lady? Because Mr. Autry's saying he's in control. Lisa Malone Jackson saying she's in control because the judge had said that, had affirmed her power of attorney, said she's in control. The judge says, Christmas is coming, I got to attend to this so that the caregivers know who's in control. And that was the emergency. And that's what he says in that order. That's what the Court of Appeals affirmed, that he had the right to go ahead with that hearing. And he did. And what he decided was, at the hearing, he had Mr. Bomar and Ms. Jackson, and they testified, and he took their evidence. Mr. Autry, who the judge had mentioned several times, that he needed to hear, the judge needed to hear from Mr. Autry and Ms. Blevins. They refused to come. With all due respect to everything, we can't lose sight of the best interests of Susan Davis Malone. And Judge Townsend's January the 23rd, 2024 order does that. It takes her best interest into account. And he says, all that has happened has been delays. That motion to recuse was a delay. He held that. And then he said, there's no just reason for further delay for this woman. And he appointed her daughter as a conservator and 2 independent, neutral co-conservators.
You used your time, but I have a question for you.
Please.
The second motion to recuse, it was pending, the trial court went ahead and held an evidentiary hearing.
The trial court went ahead and held an evidentiary hearing.
Well, I guess it held, but I don't know. It held a hearing.
No, it held an evidentiary hearing on December the 14th because there was an emergency as to who was supposed to take care of Ms. Malone. Ms. Jackson.
How
Ms.
does
Malone.
the court get around the recusal motion?
Well, the Court of Appeals held, this court held, that the trial court acted properly in finding good cause under Rule 10b to go ahead with the hearing on the emergency action to protect Ms. Malone during the Christmas holidays when the court otherwise wasn't going to be there. The Court of Appeals decision by Judge Frierson affirmed that and the propriety of that, and found that he had good cause to go ahead in spite of the pendency of the recusal motion, which, by the way, was filed at 11:50 p.m. the day before the hearing was to take place. So, Your Honor, your court has already permitted or stated that there was good cause for him, for Judge Townsend to act as he did. Judge Townsend, in this regard, appears, at least from Mr. Autry's standpoint, to be the great scapegoat, along with everybody else he accuses of being conspirators.
You've used your time.
Thank you, Your Honor. By the way, your good fortune is Shelby County's bad fortune.
Thank Thank you, Mr. Wade.
Thank you. Mr. Autry? Mr. Autry, I do want you to address your reluctance to participate in these hearings. There have been some matters raised in the brief that do concern me some.
Well, Your Honor, with all due respect to Mr. Wade, if he can direct my attention to where I've alleged a conspiracy against him or Judge Townsend, I welcome the opportunity for him to do so, because
I'm not addressing that. I'm talking about attempts to contact the office and,
Well-
or the allegations, at least in the briefs, that you failed to respond to the hearings, or...
we responded. My December 12th, 2023 response was more than comprehensive for both the court. It was hand-delivered to the judge. It was hand-delivered to Mr. Wade. It articulated a number of reasons, the primary one of which was I was in a deposition that was being conducted in Little Rock, Arkansas on December the 13th. And I was participating via Zoom because I didn't want to drive to Little Rock, because you can see in some of the court orders that Judge Townsend takes judicial notice that it's a 2.5-hour drive from Little Rock to Memphis, and I should have adjourned the deposition, which I didn't organize. I was a participant in. So the December 12th response and our request to actually schedule a hearing date is more than replete with the reasons why neither myself or Ms. Blevins could be participatory. In this case, it's not about what Mr. Wade thinks of me or what I think of Mr. Wade, but I think it's highly inappropriate for a trial judge to contact my office and berate my receptionist into intervening into my office during a deposition because he demanded that he speak with me then and there. Because candidly, a hearing on 2 days' notice or 1 day's notice is inappropriate. It's highly inappropriate. And with all due respect, the Supreme Court agreed with me. It agreed, as this court well knows, January the 8th of 2025. This was not delay tactics on a recusal of a judge. The Supreme Court said certain actions of the trial court have been contrary to the orderly and efficient administration of justice. And they took it upon themselves to completely reassign this case to a different trial judge. So they agreed with me that the actions taken by the trial court were wholly inappropriate. And so this is not a hearing on the 10B, but I want to read, Mr. Wade wants to talk about, everybody doesn't want us to be appointed. What he didn't read to you about what the Guardian Lighting report stated, it was her initial report, April 5, 2023. He stopped reading where it says, the respondent is definitely suffering from diminished capacity, but she has some wherewithal. It appears as though the respondent's friends, the appellees, influenced her to such an extent that they convinced her that Ed and Hannah, the appellants, were stealing from her. She further, in her supplemental report on April the 18th, 2023, says the respondent did knowingly sign a durable general power of attorney naming these individuals, myself and Ms. Blevins, as her attorneys in fact on September the 19th, 2018, and absent some other finding from this court, the respondent's prior designations in her durable general power of attorney and healthcare power should control. Perhaps that's the reason the trial court discharged her, because she was an impediment to what he believed was in the best interest. And I will conclude with the words, or the conclusion reached by both Judge Armstrong as well as Your Honorable Judge McGee, that says we're talking about Ms. Malone's wishes, and those actions were a usurpation of Ms. Malone's estate plannings and wishes, and the autonomous decision Ms. Malone made for her own care when she was competent to do so. There's been no disagreement. She is needed of this court's attention, this court's protection. We ask the court to vacate the January 23rd, 2024 order.
Thank you.
Thank you, Your Honor.
Since this has been said several times before in these two hearings, I will reiterate it. The best interest of the ward is what this court is concerned by and what we are striving to obtain. However, the concern is also the following the procedure. So consequently, that's what we've been discussing. Having said that, we will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. Thank you. Appreciate your argument. You may be excused.